everyone, and welcome to our first Law Week session for 2020. I'm Fiona Hudson and I'm the Programs Coordinator for the Golden Valley Libraries. I'd like to begin by acknowledging the traditional owners of the land in which we meet today, and I'd like to also pay my respects to the elders, past and present. We'd like you to be a part of the conversation, and so you can post your questions in the section below. Or email us at asklawweek@gvrlc.vic.gov.au, and I'll post that in the comment section below. We'll try our best to answer your questions at the end of the presentation, but please be aware, unfortunately, our presenters cannot comment on specific personal situations and would encourage you to seek legal advice for individual issues. Today, we're discussing shared care during COVID-19. And I'm now going to welcome our three presenters from the Family Relationship Centre, Annabelle, Jann and Michelle. Welcome, ladies.
Thanks very much, Fiona. My name's Jann and I'm here with my colleagues Belle and Michelle.
Good afternoon.
We're from the CCS Family Relationship Centre based in Shepparton. We've also got outreach centres in Bendigo, Echuca, Kyneton and Deniliquin. So we work as accredited family dispute resolution practitioners, or FDRPs. Essentially, we're mediators working with parents and sometimes children who are affected by separation and divorce in order to resolve any issues and also to create sustainable parenting arrangements. As mediators, we're impartial. We're there to facilitate communication between the parties. Mediator doesn't take sides and we don't make decisions for parties. We provide a safe environment, essentially, where parties can discuss the issues in a respectful manner. So, as Fiona said, we are not providing any legal advice today. We're just providing general information. If you need legal advice, we recommend you consult a private lawyer, or for general low cost or free advice, you can consult the Family Relationship Advice Line, your legal community legal centre, or Victoria Legal Aid for advice. Thank you.
Thanks, Jann. Divorce and separation are painful, confusing and traumatic for everyone, particularly for children. Add a pandemic and things are more confusing and can definitely escalate. At this challenging time, children need support, love and contact with both parents. Some certainty is important for everyone. Developing a parenting plan or agreement helps everyone to be clear on what is expected. It reduces tension and it gives children and parents too a sense of containment and security. A parenting plan, as you'll hear during this session, puts the interests of the children first. Under the Family Law Act, the phrase is the best interests of children, and we'll unpack that during the session. A parenting plan or agreement is a goodwill agreement between parents, and the Family Law Act encourages parents to make that together. They empower you to make it together. Our process, the Family Dispute Resolution process, is there, empowered by the Family Law Act, to help you avoid expensive litigation and to help you learn to talk together as parents on a different level. Today's session will discuss issues that are raised in our practice around shared parenting. There are additional questions which have arisen around the COVID pandemic. We will tell you and describe to you a little around what we do and how family dispute resolution practice operates. Questions that have arisen during this time often include, do I have to let my child see the other parent? Can I withhold them? Or if the other parent is the one not seeing the children, how do I enforce my rights? These questions will be discussed during our session. The Family Law Act encourages and expects parents to communicate and make agreements together in the best interests of the children. There's that phrase again. This is why it's generally compulsory to attend family dispute resolution before you can access the court. You as parents know your children. You know your lifestyles. You know your timeframes. It is more appropriate that you agree together on how things will operate. However, if that can't happen and no agreements can be reached, the family court can be accessed. It's traumatic, it's expensive, it's confusing, and it's not always the agreement that you really can live with, but you're forced to live with it. So mediation is an excellent way to go forward, to find your voice. You've been intimate partners and had children, but now you're co-parents. It's a different relationship. In family dispute resolution, we tell our clients you've gone from being intimate partners to co-parents, and we liken it to becoming business partners, trying to take the emotion out of it that you may have for the other person and look at what is going to be in the best interest of this business, your children. How are you going to get the optimum results for them? How are they going to reach their best potential? We'll unpack this during the session. So what is shared parental care? Jann, I'll give that over to you.
Thanks, Michelle. Look, the term shared care typically refers to a way that children can benefit by having a meaningful relationship with both of their parents, as long as it's safe for them to do so. So, equal shared parental responsibility refers to the legal duty or the responsibility that parents have in relation to their child or children. So this relates to the care, the welfare, the development of their children, such as the day-to-day, the schooling, the cultural upbringing, any major health decisions or medical care, and of course living arrangements. Now I do want to highlight the fact that equal shared parental responsibility, which is generally the expectations of the court, is not the same as equal time. Okay, the two are separate. So parents, under the Family Law Act, there's a presumption, as I said, that both parents have equal shared responsibility unless there are valid reasons, and that's in the court's assessments for their responsibility just to fall on one parent. When there are no parenting order or consent orders in place, then there's a presumption that both parents have equal shared responsibility. And parents must make a genuine effort to consult their co-parent when making any decisions involving major long-term issues concerning the child. So for example, if the child wants to if the parent would like to change the child's school, then they need to talk to the co-parent about those arrangements. Parental responsibility applies regardless of whether the parents were ever in a relationship, whether they're married or whether they were de facto. Thank you.
Thanks, Jann. So our next question to unpack, which I'm going to put to you, Belle, is what is FDR? And do I actually have to mediate to be able to see my children?
Thanks for that question, Jann. So the answer really is no and yes. It really depends on the situation for both of you, for both parents. When I say no, generally speaking, mediation is a voluntary process. You may not need to go to mediation if both of you could have a chat and you could agree on things anyway. There are some situations, again, depending on the level of conflict between parents, some people are, comfortable enough just having some verbal arrangements and working through things between themselves. So if you're wanting to, if in case, for example, both parents cannot agree, then mediation is an option. It is a voluntary process. However, when I say yes, you may need a mediator, it's when in situations where, for example, you're wanting to go to court and wanting the court to make a decision on your parenting agreement or your parenting arrangement. In those cases, it becomes mandatory for you to try and mediate first. So under the law, the court would want you to try and look into your issues first and make arrangements for the children because they believe that you know your circumstances better, you know your children a lot better, it's a cheaper option for you to try and mediate first. And if you think about it, though, there are a lot of benefits to you trying to sort of mediate between yourselves. For one, like I said, you know your kids better, your situations better. And the other part of that is that you would have to communicate with each other throughout the whole process anyway, until your kids are old enough to make their own decisions for themselves. Um, so if in case, for example, you do decide that you want to go ahead and try mediation as an option, mediation, by the way, is another term for family dispute resolution, you'll have to go through a number of processes. Part of the process is you have to go through what we call an assessment. An assessment is one way for us to know whether the matter can be mediated or not. Okay, when I said earlier that it is mandatory to try and mediate, there are some exceptions to that. So for example, when there are some issues around family violence, child abuse, those sort of things, it may be a matter for you and your solicitor to bring to the court immediately after that. So if in case you do decide to go ahead and mediate, we'll do an assessment. We'll try and find out if mediation is a suitable process for both of you. And if it is a suitable process, then we go ahead and book you in for your mediation. If the matter, on the other hand, is not suitable to mediate because of a number of matters that we have identified through the assessment process, we then could issue you what we call a 60-hour certificate. Now, that's one terminology that you might often hear when you have a chat to your solicitor about going to court as well. The 60-hour certificate is basically a document that you take to court with you if you want to progress the matters through the court. And it's a document that is telling the court that you don't have to mediate, or they don't have to send you back and try mediating because you have already attempted mediating. All right. So in the mediations, after we've done all the assessment, we're all good to go ahead and try the mediation. It'll be an opportunity for both parties to be in the same room with one or two mediators. In the mediation, you try and come up with, some positive arrangements for the children. It's an opportunity to talk about some of the children issues or matters that you want to bring up. It is meant to be a positive process and a child-focused process where both parents could talk in a safe environment. We don't necessarily talk about past events. We understand that things had happened in the past. However, we cannot change any of that. So we try and refocus both parents on your children's best interest. And again, that concept of best interest will be discussed a bit later. But it's basically saying, we do have our concerns as parents, but we want to try and look at what's going to be in their best interest moving forward with all these arrangements that we have. So at the end of the whole mediation process, we're hoping that we'll be able to assist both parents come up with some positive child arrangements and hopefully avoid having to go to court. And it's a bit more beneficial in a sense. And although we sort of mentioned earlier as well, what you come up with in mediation is not legally binding, just to put it out there. But we will discuss in a bit later that you do have some options to make it a legally binding document. But having said that, like I said, depending on the level of conflict between parents, if parents could agree, you don't even have to make it a legally binding document if you don't have to. Yeah, so that is basically the dispute resolution, the family dispute resolution process in a nutshell. Not unless you, Jann and Michelle, have anything else to add to that?
No, thank you, Belle.
No worries.
One of the things we often hear parents say is, it's my right to see my child, or I pay child support, I should have the right to see them when I want to see them. We hear a lot of parents talking about their rights, but actually under the Family Law Act, you may be surprised to hear that parents don't have rights. Children have rights, and I'll talk about those in a moment, but parents have responsibility, as Jann has alluded to. So as parents, the law makes us responsible for a child's physical care, a child's emotional stability, a child's changing needs as they grow, the child's protection, and particularly to be protected and not to be exposed to harmful parental conflict, and the right to cooperation with each other, with the parents cooperating with each other. And so the children's parents are making decisions in their best interest. On the other hand, parents have responsibility. The responsibility to make sure the child is safe. to make sure the child is emotionally stable, to have good communication with the other parent, to be protected from any harm or parental conflict. So the reverse, so the children's rights become the parent's responsibility. Jann, we've heard about the family dispute resolution process. We've heard a bit about what the Family Law Act says about who's responsible and who has rights. And now we're in a situation where we have a pandemic. So something else is being put into the mix, which may affect families operating under their normal circumstances with seeing children or children seeing parents and extended family. So what is shared parental care and how is it being impacted under COVID?
Thanks, Michelle. So look, you heard me say before that children have a right to a meaningful relationship with each of their parents. Of course, COVID-19 has put us all into a bit of a spin. But at the end of the day, whether you've got court orders in place or whether you've got an informal agreement in place, children still have the right to have a relationship with their parent, and things should still continue as normal. So you are permitted to leave the house to take children from one parent's place to another, and children have that right again. So when it's safe, it's important to maintain that routine for children. And when the court orders that a parenting plan is in place, then they should be followed, unless you've got a reasonable excuse not to do so. And that's a reasonable excuse in the court's eyes. So by reasonable excuse, this could include where a co-parent needs to quarantine due to recent travel, for example, or illness, or if one of the parents have been directed by a healthcare professional to quarantine. So in those cases where the child or the children can't physically spend time with their parent, it's really important that the co-parent makes every effort to maintain communication for the children's sake. And that could be via phone, via FaceTime or Zoom or any other electronic means. So if you do withhold a child due to COVID, then your co-parent can make an application to court to contravene you. If you believe you're justified in withholding your child from your co-parent, then you should get legal advice. Finally, if you and your co-parent agree that the child or children stay with one parent during the quarantine or isolation period, then it's really important to get that in writing from both parents. And it could be through an email or it can be a written copy, and outline how long that deviation from the plan, I guess, is going to take. It could be that for 2 weeks, this is going to happen. The children will stay with one parent. Just get it in writing. And again, if you're not sure what to do, please seek legal advice, either through a private lawyer, through a community legal centre in your area, legal aid, and of course the family relationship advice line. Have lawyers to talk to you about that. Thanks, Michelle.
Thanks, Jann. One of the other questions which has arisen over this time is what happens when there's a supervised visit over this time? Can they still go ahead? Now, our experience during this time is that some of the supervised centres are still open, but some are definitely closed. Supervised visits can take place, for those of you who don't know, a supervised visit is where one parent can only see the children with supervision. Sometimes it's been agreed that that supervision will be with another family member, perhaps a grandparent or an aunt or an uncle. At other times it's at an actual supervised children's centre run by an independent third party. And there are also private organisations where you pay a fee and a person will supervise the visit. Now, we have had experience over this time that some of those centres are still operating, but some are definitely closed. So you would need to contact the centre and see what their situation is.
Michelle, if I may just add to that as well. So the Family Court of Australia and the Federal Circuit Court of Australia has launched what they call a COVID-19 list as well. And what the guidance is that from there, if you have supervised contact and your center had closed, for example, and parents could not agree on an alternative arrangement, that could be one of the reasons where you could apply to court, so they could look into that as well. So you'd have to go through a process. There's a bit of a triage that happens to see whether it's eligible to be included in the COVID list. If it is, you have a 72-hour wait time, I think, from memory, in which case they'd have to deal with it, or they can deal with it. As of last time, they're dealing with all of the matters electronically, but that's an option for parents as well, if they've got some concerns around supervised contact not happening in the meantime.
Thanks, Belle. Our next question for you, Jann. What happens with the parenting plan? Can it be turned into a legal document? Talk us through that.
Okay, thanks, Michelle. So an agreement reached in mediation, generally speaking, is not a legally binding document, okay? So when we mediate at CCS Family Relationship Services, generally speaking, our agreements or the agreements made with our co-parents are good faith agreements. Okay, so they've negotiated, they've come up with a plan, we can write that down for them, and they can go on their merry way. And for many of our clients, that's enough. Sometimes parents like to sign and date the document. So if it's not signed or dated, there's no evidence that the parents have made that agreement. Once you sign and date the document, then there's evidence. But at this point, it's still not a breachable document. So you still can't go to court and say that your co-parent has failed to do something. At this point, you may need to have your orders converted into consent, so your agreement converted into consent orders. So you can do this by applying to the court. You can have a written agreement plan which the court will approve, or you can go to your lawyer and have them draw it up for you. But often, if both parents agree, you don't necessarily need to go down the legal path or through court to get consent orders. A lot of our clients are quite happy with an unsigned agreement, and that's often because the parents, generally speaking, have a good co-parenting relationship. They might come in just to fine-tune a few little points. They might be starting on their co-parenting journey and they just want to get things sorted out so that they have a good understanding of what's happening from week to week for school holidays, around Christmas, and they're quite happy with an unsigned plan. Some people might like just to take that a step further. It's really if you perhaps don't have such a good co-parenting relationship, that's when we find people are generally going down the legal path to get those orders converted into consent orders. Again, before the mediation process and perhaps during or even after the mediation process, we do urge you to get legal advice. Again, you can get free advice through community centres, or you can go to your lawyer, your private lawyer, and get some advice. So essentially you have several options. You can have an unsigned agreement, you can have a signed agreement, you can convert into consent orders.
I suppose too, Jen, the thing that parents would need to be mindful of when you do come up with this sort of agreements, they're not set in stone. We have to be mindful that they'd have to be flexible enough. It needs to be reviewed every so often, just because that our children's needs will change. Our situation will change as well. So we'll need to be mindful of that. And what we've seen had worked really well for a lot of these parenting arrangements or agreements anyway, are the ones that are quite flexible enough that people or parents are able to make changes as they go when they need to make changes. And, be cooperative enough to be able to make those changes and then move along, Again, our kids will have different needs as they grow. So again, that's something that we need to be mindful. Nothing can be set in stone. So even if you have, for example, a parenting order set in place, you can make amendments to those, cooperatively, as long as you both are in agreement that it is in the best interest of your children to change the agreement in a certain way.
That's right, Belle. And I often tell my clients that a parenting plan may only be good for a couple of years because of the changing needs of the children and perhaps the changing needs of the parents. If a parent moves away, then other plans need to put in place. I just want to reiterate that a parenting plan, it's not legally enforceable. And also, if you have a parenting order or consent orders in place, then a plan can be changed. Okay, again, you can come along to mediation and put steps in place to change those plans, and they sit alongside the court orders.
A question, Jane.
Yeah.
If parents have come to us and or between themselves made a parenting agreement, they've signed and dated it, do they have to go to a lawyer to turn that into a consent order, or is there a process where they can do that themselves?
Yes, they can apply to the court to do that themselves, Michelle. So you can find that online, the family courts. Thanks. Yep.
Just one other question. Parents sometimes come to us and say, oh, my child wants this or my child wants that in the agreement. What is the family dispute resolution practitioner's view on children's input into arrangements?
Well, Michelle, at the end of the day, it's about parents making parental decisions for their children. Okay, it's about leaving children to be children, and parents making those important decisions about their kids. Having said that, we do actually offer child inclusive mediation, where the children spend some time with a specially trained practitioner, and they discuss the needs of the child. What would the child like to see? What's concerning the child? Often things that we're not expecting to hear come out of these sessions, which is really informative for parents. That information, with the child's consent, is fed back to the parents, so they're now armed with all of that information, and that will help them hopefully make some more informed decisions when they're making their parenting plans arrangements.
Thanks, Jann. I guess when children sometimes say, I don't want to go, and put up resistance about seeing the other parent, we as FDRPs often encourage parents that sometimes the child feels conflicted, because when they're with one parent, they want to say and do what that parent wants to hear to please that parent. And when they're with the other parent, they say and do what that other parent wants to hear and see because they want to please that parent. Children love each parent 100%, and both parents are part of them, so often they feel conflicted. So communication is a real critical key for children. Their parents are communicating, they feel safe, and they know that the parents are communicating about them in a respectful way. So Jann, what are some of the things that, in thinking about a parenting plan or agreement, you've talked about being able to be flexible and make changes, but part of the parenting plan is to have certainty so that people feel secure. What can we put in the parenting plan to allow for flexibility and be respectful to the other parent if, due to work or some other reason, we need to change the spending time arrangement in a particular month or something like that?
Well, it's really up to the parents, Michelle. We don't actually tell people what to do in mediation. It's about supporting parents to come up with decisions with their families. And in some situations, parents do not wish to be flexible. They want things written down in their parenting plans and they want them to be unchangeable. And that's their decision. In other situations, parents actually actively write into their parenting plans around flexibility. Sometimes they have discussions about that and lengthy discussions about that in mediation, but don't always choose to have that written into the parenting plan. So we'll only write in the parenting plan what a parent or what both parents would like us to put up there. There's actually often a lot of dialogue that happens in the mediation that doesn't make it into the parenting plan. At the end of the day, that's the parent's decision. We can't tell you, again, we can't tell parents what to do. I would like to tap on something you said earlier though, Michelle, about the children, and sometimes they may struggle going to one parent's place over another. That's something that is really interesting to unpack with children during a child inclusive mediation process. It's not always evident why a child doesn't particularly want to go to another parent's place or the co-parent's place. So that's a great medium to find out what's actually going on in the children's world, and to be able to share that back to parents. Often it can be surprising. Absolutely, it can be something that informs the parents to make plans moving forward.
Yes,
It's about leave the past in the past. It's time to start moving forward and making those plans going forward for your children.
Yeah, I was just going to add to what Jann was saying as well. As mediators, you're right in saying that we don't tell parents what they need to talk about, how they make decisions and things, but we try and help them problem solve, come up with solutions, making sure that the children are in the center of that decision making. What we do know from studies from a long, long time ago as well, before the amendments to the Family Law Act, is that the thing that really affects children is the ongoing conflict. And that's what we're trying to help parents try and manage through the co-parenting journey. So years ago, before they made amendment to the Family Law Act, and this could come about as quite striking as well, is that they felt that children from separate family in general seemed like they were the ones performing poorly compared to those who are from intact family. But then out of that research, it came about that the reason why that's happened is not the actual separation of the parents. That's not the reason why they're performing poorly. It's the ongoing pervasive conflict that never ever gets resolved. So in the mediation process, that's something that we try and help parents to try and manage, how they manage conflict without involving the kids in the adult conversations, in the conflict, and making sure that they remain kids and be kids and parents be the parents in the whole process.
Thanks, Belle. Here at the Family Relationship Centre, we are all for supporting families and helping families in difficult times, through separation, through conflict. Belle, perhaps you could expand on some of the services we offer, because we do more than mediations, but Belle, over to you.
No worries. So the Family Relationship CCS is just one among many that you will find across the country. So we are a government-funded entity. We provide mediation services, one of the services, but more than that, we do provide family services. So when we talk about family services, we talk about services that strengthen family relationships. We talk about services that assist families through separation, helping families reconnect or stay connected. We focus parents on the needs of their children as part of the services. We understand that separation, for example, is a difficult process. It's quite a challenging process. And parents themselves may be going through some challenging times through this process. So we do provide some support for them. We provide some counseling around that. But we also provide support and counseling for children who may have maybe having some difficulties unpacking, having to deal with the changes and moving houses and what's going on with mom and dad or the parents. So again, that's another part of the service that we do provide. There are quite a lot of information that we have on the website. If you search, for example, Family Relationship Center, there are a lot of information that you can get from there. If you need additional information, we're there as well. Give us a call. Our main Family Relationship Center is based in Shepparton, but we do have, as Jann had mentioned earlier, we do have outreach offices, satellite offices where we could help you as well. So do give us a call if you need information. We'd be able to send you some information packs as well.
And Belle, just while we've got you there, I think we did have a question come in prior to the webinar that needs to be addressed.
Yeah, I think we did receive a question about parental alienation, and I'd encourage both of you to help me out here as well. Parental alienation as a concept in itself is more of a legal matter. It is not necessarily something that we talk about in mediation. It might be better for you to get some legal advice around that. I might suggest if you can have a chat to a family lawyer who is quite specialized in that area, it might be a good idea as well. Jann had mentioned your community legal center, you don't have to, they're low cost, you don't have to pay for them, for the services, or you have Victoria Legal Aid to get your service, to get some legal advice around that as well. What we do talk about in mediation are some of the expectations around what we can do as parents, making sure that we have the children's best interest. Again, you have those two key concepts that were discussed earlier. As long as parents make sure that kids have a meaningful relationship with both parents, and as long as kids are protected from harm, those are the key considerations in the mediation anyway.
And I guess, Belle, also our family counsellors can also help families who could be struggling with this issue.
Definitely. Yep. We have parenting support. We have support for children who's gone through some trauma as well. We've got a number of programs that you could look into. And we do offer some of those services anyway when we do our assessment, when we have a chat to you. As we go and identify some areas where we could maybe assist, we do offer those services. And that's, parents are able to take up the offer.
And just to talk around the COVID issue at the moment of not having direct client contact, we are offering our counselling services and our parenting courses, our counselling services over the phone, our parenting courses online. So we're still running some fantastic parenting courses, and we encourage you to have a look at our website. It's parenting post-separation, tuning into kids, tuning into teens, introducing new partners. There's a whole range of support courses that we run for parents, and we encourage you to access those if they're appropriate for you.
Can I just address alienation a little bit further, Michelle and Belle?
Yes, Jann.
There is an expectation by the family law courts that co-parents attend mediation before taking legal action, and that's really important. However, when part of the assessment process for mediation is whether parents are willing to negotiate, and again, there is an expectation that parents are willing to negotiate, and if they can't, then we're required to issue a Section 60I certificate so that legal action can be commenced by the alienated parent.
All right. I'm not sure whether we have any more questions that have come in during the webinar, Belle.
Well, I'm not too sure whether maybe Fiona could guide us whether we've got any questions at all.
Hi, ladies. Well, no, we did have a couple of questions come in, but I think they've been well covered in your presentation. It was quite comprehensive. So I think they've been covered, but I will put the links, or the link that Michelle talked about, I'll put that in the comments section below for people if they would like to go and visit and have a look at that site. I was going to say that we will be monitoring the post section of this video, and so if you're watching this not live but later tonight or tomorrow, then still feel free to pop your question in, and I'll definitely get the information and we'll post the answer from Annabelle, Jann or Michelle, in the next 24, 48 hours. The video will be up for a period of time, but once the regulations or restrictions change again, then, and if there is any content that is inaccurate, then we will take the video down so that not to conflict. So I'd like to thank you, ladies, if that's all we've got covered for today. Thank you very much for your time and for sharing your expertise with us. It was very informative, and I think just general information there, as well as to COVID, with this situation that's happening around us. As I said, make sure you put your comments in if you have any questions, if you're watching this later, because we will be monitoring that. And we'll just say thank you very much for joining us, and we'll see you tomorrow at 3 p.m. for our presentation on the prevention of elder abuse.
Thanks, Fiona.
Thank you.
Very much. Thank you.
Thank you.